Good luck, Mr. Wynn.
Right off the bat, this hearing might seem routine, but moments like this can quietly shape the entire direction of a criminal case. No attorney has officially appeared for the defendant yet, and that's a big deal. In the legal world, showing up without confirmed counsel can seriously affect strategy, deadlines, and even trial preparation.
Good morning, Miss Martin.
Morning.
So as we did last month, I set this today. I still do not see a notice of appearance from anybody.
Yes, we have to get one more payment to him.
Okay. I am going to go ahead and appoint a public defender.
This is actually a protective move by the judge. Courts don't want a defendant accidentally losing their speedy trial rights, just because they're still figuring out their legal representation. So the judge appoints a public defender temporarily, basically a legal safety net until a private lawyer officially steps in.
If somebody notices in for you, then the public defender will withdraw, but it's just, speedy trial is coming up, not immediately, but it's something that you need to be aware of and have some advice about. And I don't think, Mr. Wizork, I don't think any kind of discovery has gone underway at this point, has there?
And now things escalate quickly. The prosecution is already asking for a trial date. That means the state believes the case is ready to move forward. But here's the catch. The defense doesn't even have discovery yet. That's like being asked to run a race before you've even tied your shoes.
So we need to get the ball rolling, and I'm going to appoint the public defender to represent you now. If things do not work out with your attorney, then they'll be representing you. And if they do, like I said, they can withdraw from the case, and then the attorney you hire will take over.
This is where the courtroom logistics come into play. There are 2 defendants in related cases, and the court has to decide who goes first. Trials involving multiple defendants can become incredibly complex. Question for you watching. Do you think trying one defendant before the other could influence how the second trial plays out?
Is that okay?
Yes, ma'am. Thank you.
All right.
In addition to the appointment of counsel for defendant Martin this morning, the state is also requesting that the court set the case for trial during the month of February. Yesterday, the court set co-defendant sessions for trial. The trial term begins on February the 3rd. It would seem that based upon the current paths of each defendant and based upon the difference in their charges, it would be most appropriate to try defendant sessions first during the week of February 3rd, and then we would need to begin defendant Martin's trial the following week. I think we could complete defendant sessions in 1 week.
Notice what the judge just did here. She's setting the trial date, even though she expects it might be postponed. That's actually strategic. Courts often schedule trials early to keep the case inside the legal time limits for a speedy trial, even if attorneys later request more preparation time.
But defendant Martin's case, I would expect, would take a longer period of time.
I would imagine,
Yes, ma'am.
yeah, jury selection will even be that. So,
Yes, ma'am. And of course, that might affect the court's own calendar, given the length of this trial, because I think otherwise the trial term would only be those 2 weeks, and that might require more time off of the court's calendar in order to...
So here's where things stand. The defendant now has a temporary public defender. The prosecution is pushing toward a February trial, and the clock is officially ticking. The big question now, will a private attorney step in before the next hearing, or will the public defender end up handling one of the most important phases of this case?
Complete defendant Martin's trial.
So, and this is really for control purposes, because I sincerely believe any attorney appointed or retained is likely going to ask for a continuance, but perhaps not. So that we are within the speedy trial limits, I am setting your trial for the week of February 3rd anticipating we would start the second week, which is February 10th. Pre-trial would be January 23rd at 9 a.m. But I think it might be wise to just go ahead and set another status date before that, just to make sure that things are rolling along.
Yes, ma'am.
You have a hearing date in December after your PNC.
That's what I'm looking for. I don't think oh, we have the 27th, don't we?
December?
Mm-hmm.
That Friday?
Yes.
Yes.
All right. December 27th at 9 a.m. And it really will just be a status. Hopefully your attorney will be on board by then. Okay? All right. Thank you.
Oh, actually, Judge,
Yes. Sorry.
Ms. Martin. Could we possibly, since I have the bond hearing on Mr. Mosley on the 23rd, and this status hearing will not be long at all, can we do it on the 23rd?
That's fine.
That would be better for my calendar.
Or actually, Judge, even better than that, because Mr. Camuccio and I both have to be here on Friday, December 20th, and
That's fine.
yeah, maybe that would be even better.
We'll all be here. So that status, instead of the 27th, I'll make it the 20th?
Yes, ma'am.
At 9, what time are we doing?
9, I think. Yep. Okay.
Since we are on the record, Ms. Martin, you need, whoever you are talking to as an attorney, you need to let them know that this case has been set for trial in February, so whatever deal you're working out with them needs to be expedited, and they need to contact us when they're your official attorney, okay?
Thank you.
That's our state attorney. Okay. Thank you, Ms. Martin. I'll see you in December and get this all underway. Okay.
Thank you, Judge.
Thank you, gentlemen.
Thank you, ma'am. Have a good holiday.
Thank you. You too. Happy Thanksgiving.
Thank you.
He's my first private attorney that signed that there. Clients in custody.